5 seconds to go. Start. It is submitted that as such there are concurrent findings recorded by the courts below, namely the learned trial court, the first appellate court, and thereafter by the High Court, and therefore the interference in exercise of the powers under Article 136 of the Constitution is not warranted. It is submitted that therefore the High Court's order passed in exercise of its revisional jurisdiction does not call for any interference under Article 136 of the Constitution. It is further submitted that the learned trial court, first appellate court, and the revisional court as such have rightly appreciated the evidence of PW1 complainant, PW2 injured witness, PW10 doctor who treated PW1 and PW2, and PW13 SI who registered the FIR. It is submitted that injured eyewitnesses PW1 and PW2 were brought to the hospital by PW3 eyewitness at about 11:55 p.m. on 19th August 1996. PW10 treated PW1 and PW2 and made entries in the accident register that on receiving information from the government hospital, PW13 went to hospital and recorded the statement of PW1 at 2:30 am and came to the police to register the FIR at 3 am, which was marked as Exhibit P1. It is submitted that as PW1's fingers of both hands had serious injuries, which is corroborated by medical evidence, he was only able to affix the thumb impression on the complaint. It is submitted that discrepancy in PW1's testimony regarding him becoming unconscious immediately after he was injured may not be used against him, as the said statement was made after a lapse of 14 years from the date of occurrence. It is submitted that as such, on the careful reading of the evidence of PW1, it can be understood to mean PW1 went unconscious only after giving a complaint to PW13. It is submitted that as rightly appreciated by both the trial court and the appellate court, the testimonies of PW10 and PW13 are corroborated and correspond to the testimony of the prosecution witnesses. It is submitted that the ocular and the medical evidence in this case are corroborated and do not call for any adverse interference. It is submitted that in the present case, failure to perform test identification parade TIP is not fatal to prosecution's case because there is other overwhelming evidence including witness accounts of injured PW1 and PW2 pointing to the guilt of the accused. It is submitted that it is well settled law that TIP is not a substantive piece of evidence and may only be relied upon when the substantial evidence is uncorroborated. Identification tests are primarily meant for the purpose of helping the investigating agency with an assurance that their progress with the investigation into the offence is proceeding on the right lines. It is submitted that as such there is no provision in the Code of Criminal Procedure which obliges the investigating agency to hold or confers a right upon the accused to claim a TIP. Reliance is placed on the decision of this court in Harbhajan Singh versus State of Jammu and Kashmir 1975 4 SCC 480. It is further submitted that in the present case, the prosecution has clearly established the presence of 5 accused. It is submitted that even the charge sheet was filed against the 5 accused persons. However, 2 accused absconded and therefore the trial proceeded against 3 accused. It is submitted that otherwise there is ample evidence to show the involvement of 5 accused persons and therefore section 395 IPC will be attracted. It is further submitted that in the present case the presence of A1 Ganeshan has been established by the prosecution by examining PW6, PW11 and PW14. It is submitted that wide exhibit P10 A1 was arrested on 21st August 1996. It is further submitted that even the presence of 5 persons involved in commission of the offence has been established and proved and section 395 IPC shall be attracted. It is submitted that although PW11 turned hostile, it is a settled principle in law that evidence of hostile witness can be relied upon to the extent it supported the case of the prosecution. Reliance is placed on the judgment of this court in Satyanarayanan versus State represented by Inspector of Police 2012 12 SCC 627. It is submitted that during the confession of A2 before the investigating officer about the point. Stop.